I'm Ben Meiselas from the MeidasTouch Network. Lawyers for E. Jean Carroll in her defamation case, currently before the Southern District of New York Federal Court, have revealed in recent court filings that they have set Donald Trump's deposition in that matter for October 19th. And E. Jean Carroll's lawyer, Roberta Kaplan, argues that there should be no further delays whatsoever and that Donald Trump should absolutely be deposed on October 19th. This was in response to a letter from Donald Trump's lawyers middle of the week stating that the deadlines for the deposition should be extended. Donald Trump should not be deposed on October 19th in light of a recent ruling by the Second Circuit Court of Appeals in New York. And very recently, what the Second Circuit Court of Appeals said is that in connection with this law that defines the specific roles of presidents and government officials, that Donald Trump in 2019, when it was alleged by E. Jean Carroll that he defamed her, at that time, while he was giving the press conference, the Second Circuit held that he was technically considered a government employee. And everybody may recall what happened here with this case. If not, I can take a step back and just give you a brief primer before going into the Second Circuit Court of Appeals ruling there. E. Jean Carroll files the lawsuit in New York State Court. She's about to get discovery in New York State Court. And then Bill Barr swoops in, and Bill Barr asserts that the United States government in the USA should be substituted as a defendant instead of Donald Trump. And the underlying allegations from E. Jean Carroll was that Donald Trump gave a press conference. In the press conference, he made a number of false and defamatory statements about her and stating that he did not sexually assault her many years before he was president at an upscale department store. And he also made a number of very derogatory statements about her and her appearance. And then Bill Barr swoops in, says that in connection with E. Jean Carroll's defamation lawsuit against Donald Trump, arising out of those events, that it took place within the course and scope of his employment, and he was employed by the United States government at that time. Therefore, the case should be styled as E. Jean Carroll versus the United States and not versus Donald Trump, because of a doctrine called sovereign immunity, and where the government has to waive sovereign immunity in order for government officials to be sued for various causes of action. The government has not waived sovereign immunity as it relates to defamation claims. So, by substituting the United States as a defendant in the case, instead of Donald Trump, it would be E. Jean Carroll versus an entity that, based on the doctrine of sovereign immunity, could not be sued here, and therefore the case would immediately be dismissed. The case was removed to federal court because of the intervention by Bill Barr and the Department of Justice. And then this worked its way up to the Court of Appeals. And just this past week, what the Court of Appeals ruled was that Donald Trump fit the definition of an employee. However, to determine if he was in the course and scope of his employment, the D.C. Appeals Court, which is the highest court in Washington, D.C., the District of Columbia Court, they would be asked a question by the Second Circuit, because the choice of law at issue is D.C. choice of law. And so what the Second Circuit did is they said, we're going to certify the question about course and scope of employment to the D.C. Court of Appeals. They will answer the question about when Donald Trump made these statements about E. Jean Carroll that would be defamatory. Did they take place in the course and scope of Donald Trump's employment, which the Second Circuit found that he was employed by the United States government? And so that question is now going to be before the D.C. Court of Appeals. And what E. Jean Carroll's lawyers are saying is that's going to take a lot of time. We should not slow down in any event Donald Trump from having his deposition taken on October 19th. And Trump is saying, in light of what the Second Circuit Court of Appeals ruled, that he's an employee, and the fact that we're waiting on a ruling now from the D.C. Court of Appeals to direct the Second Circuit about this issue of course and scope of employment, we should wait and Donald Trump should not have his deposition taken. Now, one of the other factors to consider here as well is this case at issue that was filed by E. Jean Carroll is a defamation lawsuit, right? Saying that these statements were false and caused harm to her reputation. And the statements that were false relate to him saying that she is a liar and made up false accusations that she was raped by him. Why couldn't she actually bring the case against him for rape? Well, New York's statute of limitations, which provides the time frame within which people are allowed to sue after an act occurred, had already expired in New York, so she could not sue him for the underlying sexual assault and rape. But what has happened in New York? Well, New York has just passed, and Governor Hochul signed into law, the Adult Survivors Act. Now, the statute of limitation in New York for people who are victims of sexual assault was extended 20 years. So it's a 20-year time period from the date of a sexual assault within which you can file a lawsuit if you are a victim of sexual assault in New York. However, for people who were previously sexually assaulted before the law, because the law is prospective and not retroactive, this law had to be passed, called the New York Adult Survivors Act, which was signed into law by Governor Hochul, which provides an additional 1 year for people to sue regardless of it happening in the past. You have a 1 year window, even if your statute of limitations passed, within which to bring a case if your statute of limitations already expired, like E. Jean Carroll's did. So starting from when this law is officially comes into effect, which I believe is in about mid-November, I think it's November 22nd or November 23rd, E. Jean Carroll will have 1 year under the new New York law to sue Donald Trump for the sexual assault that she alleges took place many, many, many years ago, where the statute of limitations previously expired. So one of the things that E. Jean's lawyers, Roberta Kaplan, is asking the federal judge is she's saying, look, regardless of what is happening with this other case, we are going to file the lawsuit against Donald Trump for his sexual assault on E. Jean Carroll under the New York Adult Survivors Act. And therefore, we should take his deposition anyway, because he's going to be deposed one way or another. And so E. Jean Carroll will sue Donald Trump as soon as the law takes effect in November. And everybody who's watching this video should also be aware of that law if you are a victim of sexual assault in New York, to know what your rights are, that you have a 1 year, just like E. Jean Carroll will, if your statute of limitations already expired, to file a lawsuit if it occurred in the state of New York. And if you were a victim of sexual assault in New York from the date of the incident, if it happened after the bill in the future, you now have 20 years to file that. Just so you know, that those are the types of cases that I handle as a litigator in this case. And if you did want to reach out because you have a case in the past, or you have one for the future, I'm okay. If you want to reach out to me, you can reach out to me at ben@MeidasTouch.com. That's BEN at MEIDASTOUCH. I'd be happy to take a look at it and review it, and whether I could handle it or another lawyer I know I can refer to. If you feel free to send me an email, I'd be happy to take a look at it for you, ben@MeidasTouch.com. And so we will see if Donald Trump is deposed on October 19th, but the wheels of justice are moving. Donald Trump will be deposed either October 19th or sometime soon thereafter, and he's going to get sued under the Adult Survivors Act with the extension of the statute of limitations. So we will keep you posted on that. We'll keep you posted on the status of what's going on in the Court of Appeals as well. For now, I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now if you like this independent media content. We're on our way to 1 million subs. Also, if you want to support independent media like this, go to patreon.com/MeidasTouch, patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's different membership tiers. Choose the one that you think best suits you, and that's how you could help grow this independent media channel. Until next time, I'm Ben Meiselas from the MeidasTouch Network.
This November is Rovember. MeidasTouch just released its brand new collection of Rovember t-shirts and pins to let the country know what's at stake this upcoming midterm election. Go to store.MeidasTouch.com to grab yours. That's store.MeidasTouch.com.